I asked Representative Jones to be in the chair on House Bill 1287, and we will proceed with the initial amendment as House Amendment number 5. Representative Jones.
Representative Hoffman is recognized to present House Bill 1287, House Amendment number 5.
As you know, we've been called back to session to deal with the issue of workers' compensation. House Amendment number 5 goes to the core of many of the issues that the governor has been talking about, and that is the issue of causation. There have been Supreme Court rulings in Ventura and Newburgh regarding traveling employees, and Sabaro versus the Commission and Caterpillar versus the Commission regarding the whole issue of arising out of and in the course of employment. What we would do is we would codify these two Supreme Court decisions, thereby for the first time putting into law the standards by which we will determine whether a person was injured arising out of or in the course of employment, and we would define when a traveling employee doctrine, we would define the traveling employee doctrine for the purpose of workers' compensation and the purposes of compensating an injured employee. I ask for favorable consideration.
Before we proceed, we have a number of opponents. We have 2 seeking oral testimony, Mark Densler from the Illinois Manufacturers Association and the Honorable Jay Shattuck from the Illinois Chamber Technology Manufacturing Associated Builders and Contractors.
Mr. Chairman and members of the committee, greatly appreciate, again, the time that the committee is putting into this issue. I'm Jay Shattuck, representing the Illinois Chamber Technology Manufacturers Association and Associated Builders and Contractors. You've spent many hours in not only House floor, but also in this committee in hearing our testimony regarding workers' compensation reform and law, so that we can half a dozen cases that have expanded the liability. The case law would allow for an injury where it's reasonable or foreseen by the employer to make it a traveling employee situation, and it also would codify a decision where a personal errand was a deviation from the work activities, but as long as it was insubstantial, that it would be a workers' compensation situation where it would be a compensable injury. We think that if an individual is not engaged in an employment activity and are maybe on a traveling status, they should not be getting workers' compensation.
Do you think any travel to and from
Oh, certainly,
your
yes.
employment is
If it's a
not compensable?
work-related, work duties, responsibility of the workplace, absolutely traveling employee. We're not saying that there are not any situations that have a travel employee status, but we think the case law has now expanded it dramatically from where it was originally.
Okay, so I'm getting into a little bit of the weeds because I do not practice workers' comp law, but it's my understanding that the governor's proposal shuts down any travel as being compensable. And so you would be differing from the governor's proposal on that point?
No, I don't think that's a fair interpretation of the governor's proposal.
But this is not strong enough, is what you're saying.
Right, it's codifying.
Have you tendered any language to Representative Hoffman that would illustrate, what is workable for your groups?
Yes, and there's been several legislative proposals over the last several years that have been introduced previously, and we believe that those would provide for a clear and more concise definition of a traveling employee. Those bills have been, I think Representative Kay has had those bills introduced this year and last year as well.
And have you worked on language, or you are tendering yours and that's
we're very
final?
willing to work on trying to find a compromise and coming up with something that will, again, move that needle forward so that employers will be able to be competitive.
Okay, thanks.
Representative Hoffman and Representative Williams.
I'd just like to to respond to that, and I appreciate the comments. Now, I sat in the working groups, and we attempted to come to some type of agreement, and legitimately, regardless of what is being put out from the second floor, we legitimately tried to work on these issues. Now, we have always, since the beginning of time, said that the workers' compensation system in Illinois, when initially passed, is a no-fault system. Now, why is it a no-fault system? It's a no-fault system because, in exchange, benefits were reduced, and you don't go to a jury. So we, for the first time, are saying, we'll meet you halfway. We'll put and codify in law causation standards that admittedly were put forward by the courts, yet are still subject to judicial activism. But we're putting them in law. Therefore, it'll limit the future of judicial activism by changing the standards. It will allow employers to ensure that they know what the law is, that they can abide by the law. And when you talk about the issue of travel, the governor's proposal said, number one, you had to be reimbursed by your employer, or you had to be driving a company car. Well, that leaves out a whole sector of employers. I'm just talking about what the governor's proposal was in our working groups, okay? So what we have done and attempted to do, and in good faith attempted to do, is meet them halfway on the issue of causation. Because over and over and over, it has been stated in the press that the governor is demanding on workers' compensation reform some type of causation reform. We are meeting them halfway with this proposal. Now let me just repeat, and I want to repeat it. We are meeting them halfway on the issue of causation, something that is repugnant to many of our supporters, like the AFL-CIO, like the Illinois Trial Lawyers Association. They are not supporters of these proposals. They are neutral. They are not supporters or proponents of these proposals. So I just want to make that very clear, as people always want more, but by the nature of negotiation is that you negotiate. And you talk about things, and you understand that the tenet where we come from is this: injured employers should be fairly compensated. And we need to do something to bring down the cost of workers' compensation in Illinois. That's what the intent of all these amendments are, that's what the intent of this bill is, and that's what the intent of what we're trying to pass today is.
Mr. Shattuck, I see you smiling and you want to comment.
Yes, please. I'd just
Hold on
like...
a second. Before
Sure.
we'd like to add Representative Hernandez to the rolls. We're going to go to a couple members' questions, and then we'll get back to you. To add Representative Hernandez to the roll, and Representative Wheeler is recognized.
Thank you. Thank you, Mr. Chairman. Actually, I'd like to hear what Jay's response is.
To the traveling employee issue and the difference between the governor's proposal, I think one of the key differences is, and I think Mark alluded to it, is that the governor's proposal does codify the Venture Newberg parameters and standards as to what were the kind of things that if an employer did X, such as reimburse the travel, if they paid for an overnight stay, if they provided, as Representative Hoffman mentioned, a company car, then that would establish a traveling employee status. The amendment does not provide those parameters in the proposal. Meeting us halfway on causation, we're looking to find ways to save employers workers' compensation premiums without reducing benefits to injured workers. And the proposal of codifying the current situation, we don't see how there's any cost savings with that approach.
Thank you.
Just want to be mindful of members yielding time to witnesses.
Thank you, Mr. Chairman. Actually, he answered one of my questions, so we actually got something done there. Jay, with the traveling employee definition we've got here, is this model after any other states, or is this something that's kind of new?
Unfortunately, I don't have enough background information on that to be able to answer. I don't know if Mark, you got...
No, I mean, every state deals with it a little bit differently.
Okay, I'm just wondering if we can't, again, look to models that already exist and are working well to do that part of it. And this, actually, Representative Hoffman Do you have any background, or if anybody involved here, what percentage of work comp claims or awards are related to traveling employee situations?
I've not been informed of that. But I can tell you this, that the concern by employer groups has been that an individual goes off on his own and it's not directed by the employer and somehow gets injured and then gets compensated. This would indicate that it has to be directly related to the employment, and he's directed to do that. I disagree with the witness in that I am a lawyer. Maybe I'm not the best lawyer, but the governor's proposal indicates you have to be either reimbursed or in a company car. That is not what that case said, that Supreme Court case said. It didn't say that.
Right, and Jay, follow up that, is there, this language, did you guys write this, or is this from another state? I'm trying to figure out where the root this is, and if it's been used before, and if it was used, did it help where it was used?
I can say this, that, for instance, this is stricter than what, for instance, Missouri has and several other states. We took this and are codifying what the Supreme Court said. So it's the law in Illinois, but it's subject to judicial review and judicial activism. So for the first time in history, we're putting causation into the Workers' Compensation Act.
All right, thank you.
Representative Ashore.
Thank you. How would you equate this? There was a construction company, mechanical contractors, that sent one of their employees to deliver a bid. They were going to deliver a bid to a particular area. It was outside of the general area of where they worked. She used her own car. They were paying her wages, but she wasn't going to have to stay overnight or that type of thing. How would you say that case would have fallen into workman's comp?
And she was injured while she was going to the place that required her employment to take her.
No, it wasn't employment. It was just to drop off a bid. I guess I would, maybe that's...
I think that would constitute being part of her employment duties.
Yeah.
In that particular case, that would be a traveling employee, as long as she's injured on the way to her activity. I think we're trying to make sure that we don't compensate commuting to or from work, where you would be leaving your home to the workplace, coming to the workplace, or leaving the workplace to go home. I mean, there's a lot of factors that are taken into the traveling employee, but Representative, your example, I think, would be under the governor's proposal, under the proposal that the employer communities put forward in the past, and certainly under this, it would be compensable.
Well, the company fought it. The company that she was working for fought it, and she had to hire a lawyer, and our union had to get involved before she could, and it took quite a while before she ever got compensated. So I don't know whether the law has changed since then or not, but this has been probably 15 years ago. So
I would say the Venture Newberg case would have allowed, based on the parameters that Venture Newberg provided to the definition of what's a traveling employee, that she would probably been compensable and today wouldn't have as much of a fight.
Representative Brady.
Thank you very much. Jay and Mark, maybe this might be more of a statement, but if I'm hearing things correctly, we have the potential to change the act as it pertains to travel, a traveling employee, and what that definition is. And we're going to do that without anybody presenting supportive numbers of the percentage of claims of travelers and what that impact is on the workers' compensation system. No one's presented supportive data of what
The number of cases,
what the numbers are.
No,
Okay, so we're changing an act without supportive data of what it would really do.
We support the concept, and I think the intent, but just not this language. I think it's something we can work on.
Thank you.
And I might just add that I think we'll see more traveling employee cases, given the fact that the courts have expanded the definition of employee traveling over the last 5 to 10 years. And this codifies that.
Without supportive data, we're somewhat shooting in the dark here on changing this. All right, thank you.
Are there any other members seeking testimony? Questions? If not, Representative Bradley moves to adopt House Amendment number 5. Recommends be to adopt it. Mr. Clerk, are we to leave? Is leave? Partisan leave. On a vote of 16-5, House Amendment number 5 to House Bill 1287 shall be favorably reported to the House floor. Representative Hoffman is recognized to present House Amendment number 6.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. House Amendment number 6 goes to the issue that has been discussed and was discussed in the working groups to attempt to not penalize employers who just have short-term employees who may just come on the job and get injured as a result of repetitive injury. What it would indicate, it would prohibit a workers' compensation insurer from factoring into determination of premiums a workers' compensation claim for a cumulative or repetitive injury suffered within the first 3 months of employment. So in other words, in the case of a person who may be a drywaller and constantly works above his head drywalling, that and his arms are above his head, that all of a sudden after working out of the union hall, he goes to work, and because of the years of trauma and the years of the repetition, he has issues with his shoulders. What it indicates is the insurance company can't hold that against an employer if that individual was working for not at least 3 months. In addition, it would allow employers to seek contribution or reimbursement from a prior employer for the prior employer's share of responsibility for a cumulative or repetitive injury. These are both designed to help out employers and not have them suffer as a result of a short-term employee when there is a repetitive injury on the job.
We have opponents, and we also have two opponents seeking oral testimony, the Honorable Jay Shattuck again, and also Mark Denzler from the Illinois Manufacturers Association. Gentlemen, House Amendment number 6, comments?
Yes, we would also ask for a no vote on this amendment. While we think it's an effort to try to resolve some questions and concerns that the primary cause standard creates, we think that this will move us in the wrong direction. Certainly, the recognition that it's somebody who is in an occupation that requires a certain type of activity over multiple employers should be recognized as a compensable injury. We believe that the governor's proposal does address that situation in a better fashion. We're concerned a little bit as to how an employer will determine prior employees, or I should say prior employers, to be able to find contribution. We think that will raise additional costs in the system. But again, we appreciate the fact that there's recognition that we need to address some of these issues. We just don't think at this point that this amendment addresses it in the appropriate way.
Mark Denzler with the IMA, and I'll just follow up quickly on Jay's. Agree with his statement. We actually think this could increase costs for small and medium-sized businesses. So you had, as Kim Meisch has said previously and testified, a hotel here in Springfield that hired a housekeeper. She worked for approximately 6 weeks, filed a double carpal tunnel, and I think the total cost, medical and indemnity, was $140,000. So it falls within the 3 months. So we understand what you're trying to do that, but the employer still has to pay that. They still pay the medical award, they still pay the damages, and then what you're telling that small employer, that small hotel is, if you want to recover, you have to go hire an attorney and go sue other companies. So it kind of adds insult to injury that they've had to pay this, and now they have to go hire an attorney to try to recoup some of that money. So we actually think this could increase costs for some companies, so appreciate it.
Representative Hoffman.
I would just say to that everybody keeps saying we want to make sure that an individual is fairly compensated. We're attempting to spread the risk over an industry. And currently, under the governor's proposal, if you were going to say that you have to prove that you're 50% at fault, you're going to hire a heck of a lot more attorneys than you're going to hire if you tried to get compensated from previous employers. Nobody in this bill is saying that you have to hire an attorney to attempt to get compensated by previous employers. What the governor's proposals would do is it would prohibit that person from being compensated. We're not willing to do that.
Any other members' questions? Representative Wheeler?
Thank you very much, Mr. Chairman. I have a couple questions here for the sponsor. Jay, help me understand how would a self-insured company or a workers' compensation insurance company find out who the previous employers for an injured employee were?
Under our proposal, the employee is required to cooperate, to give that information.
And so if they were to not have accurate records, there would be potentially a gap where someone would get off without having to pay their fair share.
I'm sorry,
I know this is hard to do.
I know I
backwards
should
like
have
this, Jay.
probably went down there.
But if you've got a situation where an employee, let's say you've like a drywaller, a union drywaller who's gone out on multiple projects over the last period of time. If they forget one or two of those employers that they had across that spectrum of time, those employers are not going to be held liable in any way, shape, or form then.
Well, I can just say what it is under current law. Under current law, there's no ability to get contribution from previous employers. So you would be correct.
It's a step in the direction. I understand where we're going. I just want to make sure they understand the legislation that's been presented.
Yeah.
The other part is would the worker have to have worked in a similar or same work classification code in order to be,
No, it's just repetitive, if it is a result of repetitive trauma.
but if they worked in an office building versus working as a drywaller, then they'd kind of be out of step with each other.
I think what would have to happen under our proposal is the commission, which again are gubernatorial appointees. They would adopt rules that would put this into place. And so they would adopt rules regarding this to implement it.
So then if they adopted rules, then that would affect how litigation could move forward then when the company is trying to recoup those costs from a previous employer.
Well, currently they can't recoup anything.
Well, I understand.
If you don't want them to be able to recoup the cost, well, no.
I'm not arguing with your intent here.
I think
I'm
you
just
are.
understand the process.
Okay. You're arguing with me, but not the intent. I know, understand. I understand.
Get along. And then finally, help me understand the timeline part of it. Under the very last, or actually not the very last, paragraph C, it says no contribution or reimbursement may be sought for any payment of benefits more than 2 years after the employer seeking contribution or reimbursement has made the payment. How far back then can they go? On which side?
The idea is to mirror what is joint and severable liability under civil law, and that's what we attempted to do. And that has that same 2-year window.
Okay, so that you can only go, so if I have an employee who gets hurt and he files a work comp claim, it's been less than 3 months he's been my employee, I can only go back to the last 2 years worth of employer time that particular employee had, or his whole career?
Well, I think we're mixing two things.
Okay.
So the first thing indicates that if it's repetitive trauma and you work for an employer less than 3 months, you can't then use that, the insurance company can't use that as an event that would increase your rates. The second part would indicate that if it is a repetitive trauma, an employer can look at previous employers in order to get contribution towards what they may have been paying. So there's two
I'm
parts.
just talking about the latter part of it, Jay, the part where I want to recoup my cost, okay? We paid the claim to the injured employee based on repetitive trauma within the first 3 months of their employment with my company, right? Then I want to look to the previous employers to recoup that expense. I can go back how far? Unlimited?
Under the proposal, there's no limit.
Okay, so I can go back to if these guys been in business or been working for 40 years, I can go back till that period of time.
You would still have to show that there's some responsibility for that injury, so the further away from the event would be more difficult to prove.
Sorry again, say it again, Jay.
So the further away from the injury would be more difficult to prove that an employer or a previous employer 20 years ago helped cause the injury 20 years later. That's just a matter of fact.
I was actually thinking of the gentleman we had at the Work Comp Committee of the Whole, who was the, for lack of a better term, the guy who broke the rocks. Right?
The coal miner.
Yeah, exactly. His job would have been the same impact on his body through his entire career. So if he had been in multiple mines, all of them would have been potentially, I could recoup the expense back from all of them. That's what you're saying.
Yes.
Okay. That's my questions. Thank you.
And Representative Wheeler, the subparagraph C.
Mr. Shattuck.
I'm sorry.
You can't talk unless the chairman.
Sorry, Ms. Shattuck, I wasn't paying attention to you, but Ms. Shattuck, you're recognized.
Thank you, Mr. Chairman. That subparagraph C that you're referring to is a statute of limitations on the employer, so that if you don't bring an action to go back as far as you want to go back, or you can go back, you only have 2 years to do that.
Okay. Thank you.
I'd like to add Representative Cassidy to the roll. You on the roll? I'm sorry. Representative Ashore.
In regard to the previous speaker, not the previous speaker, right before the previous speaker, your question about how would they know what employers they work for or whatever, I don't know how all the unions work, but at the building trades, I can talk about that. When you go to an employer, you're referred out from that union hall, and there's a record kept on you. And so they wouldn't have any hard time keeping track of who they work for, because that would be a record in their union hall.
Are there any other members seeking testimony? Questions? Not. Representative Bradley recommends do adopt House Amendment number 6 to House Bill 1287. Is there leave? I just like saying that. Is there leave? On the partisan roll call, on 16.5, House Amendment number 6 to House Bill 1287 shall be favorably reported to the House floor. Representative Hoffman, in the chair.
Thank you, Representative. On House Amendment number 7 to House Bill 1287, Representative Bradley asked leave to present from his chair. Is there leave? Leave is granted. Please proceed.
Thank you, Mr. Chairman. 2011, when I worked with these gentlemen at the table, and let me compliment them on the efforts that were made and the eventual agreement that was reached with regards to this issue. The results of that have been basically the reduction in the NCCI rate of somewhere between 18 and 26%, and with additional anticipated or expected reductions in the advisory rate. Frustration for me, having been involved in hundreds of hours of negotiations and asking people to make sacrifices and to have a reduction in benefits, is that we have not seen sufficient proof that that's been passed on to the businesses we were trying to help. And that's very frustrating, because a lot of us really, made a tough vote, made tough decisions, and we wanted to see those results. So what House Amendment number 7 does is try to get us closer to coming up with a better idea of whether that's being passed on, those savings are being passed on to the employers, and how to get there. And so there's two components. One would provide a workers' comp task force to review the rates. It would have 12 members, 4 by the governor, 8 by the leaders. The idea again being, are these reductions in costs to the system being passed on to businesses? And the second would simply be self-insurance reporting, because part of the picture are the self-insureds in the state of Illinois, and we just don't have sufficient information right now to know to a degree of certainty what's going on with self-insurance on comp. And so again, the reforms that we did worked, and that was acknowledged at the table. And I personally, and I know a lot of people, want to know that these savings and these reductions in the costs of the system have been passed on to the businesses that we intended. So That's what I'm trying to do here, and I'm not trying to be confrontational or aggressive, simply saying, let's figure out what's going on and how we get there.
Once again, Jay Shattuck as well as Mark Denzler would like to give oral testimony, and then there are several other proponents to our task force. Unbelievable. Please proceed.
Mark Denzler with the IMA again. Nice to see you today. I'll be very brief on this, and again, thank you, Representative Bradley, for your work in 2011. I would make 2 quick points on this, and I'm going to focus on the self-insured information. First of all, there's, I think, roughly 260, 265 self-insured companies and local governments in the state of Illinois. They're about 25, 26% of the total payments and employees, so they're larger employers. So one, we would ask, we want to make sure that any data that they provide is kept confidential. I think the report talks about an aggregation, but we would just want to make sure that's in there, that company-specific information is not part of that. And then I would just make the general point that we have had the opportunity since the 2011 reform. You know, we've kind of seen a test, because you have the insured companies that buy through a competitive marketplace, 300 companies, and you have the self-insureds that don't have to go out and buy insurance. And I think we would expect that you would see a significant cost savings for the self-insureds if the insurance companies were gouging, and the insurance companies here can talk, but we haven't seen that. And so, you know, again, that is why we continue to press for additional reforms.
I think that your request personally is reasonable. I'm not making any commitment to do that. It's a reasonable request. And that's really what we're trying to find out, is what's going on with the self-insureds, because we don't sufficiently know right now. And if, in fact, there are cost savings going on there, which I anticipate that there are as a result of what we did, let's see it.
Jay Shattuck again. Thank you, Mr. Chairman, members of the committee. In addition to Mark's concerns that he raises on some of this data, and I think a good portion of this data is already being reported from a self-insured individual standpoint with the Workers' Compensation Commission. The Workers' Compensation Commission oversees those individual self-insureds in terms of making sure that they're financially solvent and administers the self-insured guarantee fund. This would require a duplication of the reporting of that data to DOI, and don't understand why we're sending additional information or the same information to DOI that's already being collected and available in an aggregate basis from the Workers' Comp Commission. Again, our concern is that this information be held in an aggregate basis and not accessible on an individual company basis, because the data could be extremely proprietary from an individual employer standpoint. And we would ask, again, for a no vote, because we don't see how this particular additional requirements of filing additional data would move the needle in towards savings and greater competition for Illinois employers. Be happy to answer any questions.
Questions, members of the committee? Seeing none, Representative Jones moves to recommend for adoption House Floor Amendment Number 7 to House Bill 1287. Is there leave? Leave for partisan roll call. 16 voting yes, 5 voting no, 0 voting present. It shall be recommended for adoption. House Floor Amendment Number 8 to House Bill 1287. Representative Bradley.
Immediate effective date.
So there are 4 opponents to an immediate effective date. There are nobody's filed for oral testimony. Representative Phelps moves do recommend for adoption House Floor Amendment Number 8 to House Bill 1287. Is there leave for partisan roll call? Is there leave for partisan roll call? Leave being granted. 16 voting yes, 5 voting no. The proposal, which is opposed by 4 people for an immediate effective date, shall be favorably reported. The House Labor and Commerce Committee shall stand in recess to the call of the chair. Thank you, ladies and gentlemen of the committee.